Trump prosecutors denied. Special counsel Jack Smith loses a little interesting skirmish here in the battle over witnesses. We remember that when Trump initially was arraigned, there was a protective order that was issued. The judge very briefly said to Trump and his defense, well, just don't talk to all the witnesses out there. And this is a normal rule that happens. If it's a domestic violence situation, example, you're a defendant. The judge says, okay, I'm going to let you out. Go home, go to work, do your things. Just don't contact the other party. You go, okay, that makes sense. The defendant doesn't contact the victim. You don't contact the other witnesses. Don't contact her. Okay, makes sense. Got it. So normally it's very routine. So the judge just said to Trump, don't contact the other witnesses. And the question was, well, what other witnesses? I mean, this is going to be a big case. There's going to be a lot of witnesses here. And Trump, as we know from the other protective order, is really limited on what notes he can take. And there's all these rules and regulations about what material he can even write notes and take out of the attorney's offices and so on. So the government came out and they asked for some more specificity on that witness list rule. They said, well, Judge, we should probably clear all this up a little bit. In fact, we want to ask you to implement some of these special conditions of release. Trump already had release conditions set. It's U.S. versus Trump. Says on June 13th, Magistrate Judge Goodman, who presided over the initial appearance, was the first court date when Trump went down there in Miami. At the hearing, Judge Goodman orally ruled that as a special condition of release, both defendants, Trump and Walt, are prohibited from communicating with certain witnesses about the facts of the case except through counsel. Don't talk to anybody about it. So, and that's a very broad rule. So the government's like, amazing. We can't wait to use that for all of our witnesses. Trump can't talk to any of these people. His hands are going to be totally tied behind his back. We can't wait for this. The court further ordered that the government provide counsel for defendants with a list of witnesses. So that means the government give to Trump lawyers a list of witnesses to whom this prohibition would apply. So they're like, oh, great, we're going to tell everybody and put Trump's entire Mar-a-Lago team on there. Then Trump can't talk to them about this. The prohibition applies to Trump. So then on June 22nd, the government gave Trump's lawyers a list of these witnesses. And look, the list does not comprise all of the other witnesses that the government might call at trial, which means we might have a big, long list. In order to implement Judge Goodman's specific and special conditions of release, the court hereby moves to file this list of witnesses under seal. Wait a minute. What? The government has conferred with Donald Trump about this motion. They've authorized to say the following. So this is Trump's response to this. Trump's team said, well, defense counsel takes no position on the motion to seal the list of witnesses, but deserves the right to object to the special condition and the manner in which it was implemented by the government giving us a list of 84 witnesses, right? That's a big list of people. In compliance with the government's request, also, they want Trump to sign an acknowledgement that he's got the list, that he's read it, and they want the government to have a copy of the executed acknowledgements. They're like, first of all, we don't think Trump's going to read this list, and so we want him to read the list. And we have 84 people on this list that he can't talk to. And so he's got to respond and say, I did my homework, and if you don't do my homework right, then you're going to be in trouble. And a proposed acknowledgement form is submitted as attachment A. This is all signed by Jay Bratt, counselor to the special counsel team. So you can see here, like it's really trying to handcuff Trump and his team. They said, wow, great. Judge Goodman at the first proceeding gave us an opening. He said, don't talk to other witnesses, Your Honor. We have now 84 witnesses Donald Trump can't talk to. And we want him to say, I know I got the list, I read it, and I promised to do it, and so on. Wow, that's pretty bold. So they send all this over to the court, and guess what? Man, the judge is not having it at all. She fired this right back. This is what the court docket looks like. This was a paperless order, meaning we don't have a formal PDF of it. But Judge Eileen Cannon submitted the following. She said, this is the order from the court denying the government's motion for those special conditions. She says the government seeks an order implementing a special condition on 84 listed witnesses about the case, which is what the government read into the first order after the initial appearance. The government conditions its request, they say, on its filing of a non-exhaustive list under seal. So meaning they've got 84 people, they want to file it under seal, and it's not even the full list. It's like, is there anything else you want? You want fries with that? Defendants take no position on the government's seal request, but reserve the right to challenge the manner in which this came into play. The government cites various laws, but the government's motion is denied. The government's motion does not explain why filing this list with the court is necessary. It does not offer a particularized basis to justify the sealing of the list. Why do we need to seal it? First of all, you're not telling me why I need to know about these 84 people. It sounds like you're asking me to just kind of be like a hall monitor for this, which I'm not going to do. You also don't give us a basis for justifying the sealing of this. It doesn't explain why a partial sealing or redaction or any other means are unavailable or not satisfactory. So the government just wants it all sealed. They just want it all done. But she says, no, open this stuff up. And so the clerk is directed to reject this, and you lose. The government was trying to squeeze something through there, and the judge rejected them and dumped them right back out. So it's a big actual victory for Trump, and it's a little bit of a backhand to the special counsel who's trying to get more than the judge gave them. We also have another update because the special counsel's office also asked for a trial continuance. We know that this trial was originally scheduled for August. Now they're asking for a December date. Here, the judge is going to rule on the request from the government. And I want to share a little bit about what this looks like because timing is going to be extremely important in this case. So what you can see is the government is asking for a continuance. It was originally scheduled for a trial in August, and now we're bumping it out. They want it to go to December 11th. Here's what they say. Your Honor, for the reasons discussed below, we're asking to postpone this trial. A declaration in support has been filed. We'll read through that. And the government have conferred with counsel for Trump and Nauta in a good faith effort to resolve this by a motion by agreement. Here, Trump's team confirmed they do not oppose an adjournment of the current trial date, meaning the current date that's set for August. They're okay moving that. And request a status hearing with the court to address and schedule in this action. So defense counsel, Trump's team, they say we want another hearing. We'll come back and we'll parse through this all together in person. Defense counsel anticipate filing an opposition motion addressing their objections to the government's dates. Okay, so Trump's okay moving it, but they're just not okay moving it to December 11th. Prosecutors tell us the following. A grand jury in this district returned an indictment on June 8th. Trump and Walt made their appearances June 13th. June 19th, Judge Reinhart granted the government's motion for a protective order, which we read through here, and we set new dates in the omnibus motion, which we reviewed. Now, they tell us that the law gives us factors that are important for continuances. Okay, you don't just get to say, well, the trial's like on the third week of the month. I just don't like the third week of the month. I'm kind of tired on the third week. Can we move it to the first week of the following month? Or, I just don't like to do trials on Thursdays or something, right? They don't care about that. It's got to be a legitimate reason and typically require exceptional circumstances in order to do it. So as an initial matter, this is the government speaking. As an initial matter, this case is not so unusual or complex as to fall within this law because it has only two defendants, involves straightforward theories of liability, and does not present novel questions of fact or law. These people are psycho. So there's a different category of criminal law where it's called complex cases. Okay, some cases are simple. It's one defendant, one crime. You have a couple charges and a simple theory of the case. If one person got a DUI, they're probably guilty of the traffic offense and maybe the possession offense and the other things. It's not complicated. There are other cases that are very complicated, and we designate those cases complex. We say, this is not the ordinary run-of-the-mill here. We've got a lot to unpack. And it's going to require, multiple court settings, multiple status conferences where we unpack all of the complexities. One theory in this case is we've got classified documents. We've got 31 of them. We've got a new novel question of law in that it's a former president. We've got questions about executive privilege, attorney-client privilege being breached, all new from the presidency. We've got questions about whether classified documents can be declassified and all of those questions under the Presidential Records Act. This is all going to bring in absolutely brand new constitutional law questions. Absolutely. It's never happened before in this country. How can it not? But these prosecutors will tell you, I can't even believe they wrote this with a straight face. And it might be straightforward to them, but it only has two defendants. It's got 84 witnesses, according to their earlier filing. These people are so dishonest, it makes you sick. However, the case does, finally they admit, involve classified information, and it will necessitate defense counsel obtaining the requisite security clearances. Meaning they're also going to try to stop Trump from even getting access to see the documents. They're going to say, he's not president anymore. He doesn't need to see this stuff. They're going to redact it. They're going to try to hide everything. They're going to make it difficult for them to get security clearances. We already know, per the prior order, Trump can't even retain possession of his notes on the case. As the court is aware, the government prosecutors say that process is already underway. According to the litigation support group, decisions on clearances for Trump's lawyers should be made within 48 hours. Fill out the right forms. Interim clearances will enable the lawyers for Trump to review the vast majority of the classified discovery. Not all of it, though. The vast majority. Interim clearances. The decision on granting the final clearance required to allow counsel to review the remaining number of small documents is going to occur within 45 to 60 days. So we're talking about a small subset of documents that actually require the higher level clearance. What number of those, we don't know. Now, in addition, the associated legal process under the Classified Information Procedures Act, called CIPA, they say under the Classified Information Procedures Act, the legal process will inject additional time in the lead up to the trial that would otherwise not be involved. Okay, so we're going to actually need more time. The government has attached a proposed calendar for the classified process, assuming a trial date with jury selection beginning December 11th. The government also filed a motion for a pretrial conference, which we reviewed. That video will be coming out. We reviewed this at our members-only stream this morning. That motion describes the CIPA proceedings that are likely to entail. Following entry of the protective order, the government has moved swiftly to produce all unclassified material, including Jenks material. So unclassified stuff has already gone over. Jenks materials all gone to the defense, and a significant portion of that started going over June 21st. Here's what is in this tranche of documents that went over to Trump. Evidence that they got from subpoena, evidence they got from warrants, transcripts of the grand jury testimony, memorialization of witness interviews, a reproduction of key documents the government says are pertinent, copies of closed-circuit TV footage that the government got during its investigation. That's probably the Mar-a-Lago footage. They say even with the prompt production the government has completed, including the additional time to review and digest and make their own decisions about production, is reasonable and appropriate. And so as a result, proceeding with trial on August 14th is not appropriate. It would deny counsel for the government reasonable time to prepare. And for the foregoing reasons, pretty simple, we ask to postpone this trial to December 11th, exclude the delay. All right, so some people will ask about speedy trial provisions and the right to a speedy trial. And you know when you see on the chessboard when people will take a move and they'll hit the button and the time stops and the other person's time starts? And then you've got the clock is ticking and going down against you, and you make your move and you press the button. It's the other side's clock starts counting. It's kind of like that. Except here, the government is saying, we're asking to press the button so the other time starts, and we don't want any of this time to count against us. We're asking for more time, in other words. Don't count this against us, because it's really for the benefit of the defense. And it's because it's a little bit of a complex case, because it's security and classified materials, but not that complex in that it justifies a complex case designation, which would really postpone this thing out probably, I don't know, maybe till the end of 2024, if it's designated complex, way out. Definitely not this year. So then continuing the calendar call, which is the date before the trial. Calendar call is like kind of final call, last call. So you come in December 5th, and then continuing all of the other deadlines to November 20th, 2023. So all submitted by David Harbach, who is a new addition to the team. He just submitted his notice of appearance. Also joined by Jay Bratt, Julie Edelstein, with proposed orders. And very briefly, this is the declaration from Jay Bratt. I'll share this briefly. But the declaration says, I'm one of the prosecutors involved. Based on my personal knowledge, this involves classified materials, and it varies from document to document. Security clearance, though, is still required to review them. No defense counsel currently has security clearance, so they got to get one. We're going to expedite this stuff, but we'll see how quickly it goes. We are committed to reaching an eligibility determination in 24 to 48 hours. So the prosecutors are in such control of the evidence that now they're able to issue security clearances, right, and determine whether Trump's team can actually see the stuff, because we've got confidential, secret, and top secret. Interim security clearances are not sufficient for the government to provide in a small number of documents, as we read in the prior motion. And so a lot of this has been turned over. He says, I've got extensive experience with this, and so you can know that I'm telling you the truth. I work for the Justice Department. I'm Jay Bratt. This is the schedule that they proposed. You can see pretty detailed here. And the important dates for us are this one, December 11th. December 5th is the calendar call. We've got motions deadlines for the Classified Information Act here, November 28th. And you can see it's going to be a busy schedule. So our next date would be August 14th for certain deadlines. And they are moving forward with this thing. This is the proposed order. But the judge has issued a response, and the judge says the following. On or before July 6th, Trump shall respond to the government's motion for a continuance, either individually, meaning Walt files his and Trump files his, or they file it together. This one's signed by Judge Cannon, very brief, and we also have a new pretrial conference scheduled on July 14th. So we'll have another update on July 14th, just a few short weeks from now. And so we're getting more filings. Trump's team is going to respond to a lot of this stuff, and it's going to continue to heat up. But a big victory for Trump in that the government asked that Trump really be limited and handcuffed. 84 witnesses are off limits. Judge Cannon says, no. That's not how that's going to work here today.